Good morning, everyone. Please give us a few moments as more people come through. We do have over 200 registered for today, so we need to give everyone a chance to come in before we kick off. All right, we still have a few people coming in, but I think we might kick off and they will no doubt come through over the next little while. Good morning, everyone. My name's Phil Anderson. I'm the CEO of the AFA, and I'm really pleased today to have Shail Singh from AFCA with us. Shail is the Acting Lead Ombudsman for Investments and Advice, so he's very much the part of AFCA that is very relevant to financial advice. The AFA has a really good relationship with AFCA. We meet on a quarterly basis, and we've known Shail through those meetings for some time. The AFA has also had the benefit of previously hearing from Shail in late 2020. Shail joined FOS in 2010. He became an ombudsman in 2018, and most recently has taken over the acting role as the lead ombudsman for Investments and Advice. Natalie Cameron is substantially in that role, and we've seen her participate at our last two conferences. So we hope to continue to work with both Natalie and Shail. Just for today, we've got a presentation that's going to look at some very relevant information from AFCA, and I think one of the things that I really like about this is the tips on how to work with AFCA and what happens when a complaint comes up. I think some of their script is around how to put AFCA out of business, which I'm sure some of us would like to see, but it might be some time before that actually happens, and that will only happen if there are no complaints going forward. We'll move quickly onto the today's program. We'll have 1 hour of CPD from today. All attendees will be on mute. And importantly, if you do have questions, please use the Q&A button rather than the chat button. So the Q&A button, and we're very fortunate to have Kaz Garrard from the AFA's Policy and Education team here to ask questions of Shail later on in the presentation. So I've got Shail in the AFA office today, and we're just going to do a very quick share slide as we move him into the screen, and we'll get Shail to take over. So thanks everyone for joining us for today, and I hope you get a lot out of the presentation. Thank you.
There we go. Thanks, Phil. Very, very smooth handover. And it's so nice to be here in person at the AFA offices. I mean, I don't think we've been in the same room together, Phil, and we've seen each other on the screens. But look, it's great to be able to talk to you today. I just had to add one thing that Phil missed in my bio, which is that I did work as an advisor before FOS. For a couple of years in a sort of a boutique financial planning company out in the suburbs of Melbourne, Bourne. So that is another aspect. So it was a really interesting experience, 2008 to 2010, at the time of the GFC. So learned a lot about client management during that time. So look, what we're going to do today is we'll go through, we will do the basics. What is AFCA? What are we all about? I won't take that long on it, but it's always good to remind people and start with the basics. I'll give you an update on a couple of things, which are our funding model. Now, we've gone out and done separate webinars around it, but it's an important change and it's a really positive one for the industry. So I just wanted to talk about that again. The independent review is the other big ticket item for us at the moment. And essentially, we're looking at 12 separate projects to improve the service that we're providing to you and consumers. I'll go through stats. I'll give you advice stats. I've got it up to date to the end of February, but I've also got numbers of general investments and advice stats through to advice matters. And I've also just done a little focus on advice as it relates to life insurance, TPD and income protection, because obviously that's an area of interest for a lot of you. I've got a couple of case studies, and again, they're going to be an insurance bent to them. Hopefully you'll find them interesting, and hopefully you'll find them reassuring, because I know lots of advisors still are worried about what AFCA will do and what AFCA will think. Part of the reason we come out here and do this is to show you what we're about, that we're transparent, that we're straightforward, that, you know, yes, we might make an error, but we will take on board feedback. We are here to be fair to both parties, and right now, you know, my feeling, it's no surprise that with 7,500 advisors left on the register, it's an important time for the industry and for growth of the industry. And the last one is how to put AFCA out of business. So some of my colleagues don't like this one, but the chief certainly does, and is very open about saying, as are the board, that whilst, you know, an EDR scheme is a fantastic thing because it's a free service to consumers and ultimately gives confidence in the industry, it would be great if we can reduce complaints or even not have any at all. And that's the purpose of this. And then we'll have some time at the end for Q&A, if there are any. And I'm going that one up and down.
Yeah, just down.
Thanks, Phil. So just basics. Who is AFCA? Well, our main responsibility is to resolve complaints. You know, I know people talk about the regulatory landscape and how complicated it is. There was AFCA, and then there's ASIC, and then there's AFCA. Of course, now no more AFCA, and you've got Treasury and ASIC and AFCA. But where do we sit? Well, we're the entity that resolves disputes between consumers and financial firms. That's our primary aim and objective. We're not here to regulate or set legislation. That is ASIC's role. Very important distinction. We identify systemic issues and work with financial firms to resolve them. There were some recommendations from the independent review about that, which I'll talk about in a minute. And we support other regulators, including APRA, the ATO, by reporting certain matters to them to inform their regulatory activity. And of course, we promote awareness of AFCA. And what that means is not only raising the profile of AFCA for consumers, because there still are studies showing that in the public domain, only 8% odd of people know about AFCA, which is not ideal. We would want it much higher. Now, there's a big difference between knowing about it and encouraging complaints. We're not encouraging complaints. We want people to know the service exists, because we believe that's important for the industry generally. And awareness of AFCA is all about also talking about our approach to various things, to show that we're real people, that we grapple with these issues, and that we try to find a balance for all parties' interests. And, you know, we're not in the popularity game, but we do try to sort of, you know, I always sort of say if a room full of advisors is there, 80 to 90% would agree with decisions that we make, even though a few might disagree. So here's the process. Comes in, registration, referral. People can lodge a dispute without bringing it up in IDR, which is always a source of angst for licensees, but we refer those matters back to give you a chance to resolve them. So we think that IDR period is really important. And you'll see from the fee review model that we're encouraging IDR more. And the better your IDR is, probably the less fees you'll end up paying at AFCA, but I'll get to that in a minute. Workflow, we then assess, is it investments, is it banking, is it, you know, credit? We review the jurisdiction, important step. That means 6-year rule. That means $1 million cap, slightly over that, $1 million cap. We have $1 million cap on jurisdiction, but on awards, it's about $500,000. Then it goes into case management, and we try to negotiate it, conciliate it, resolve it by agreement first. That's the main aim. If we can't resolve it that way, we go to a preliminary assessment where we give an initial view, and then only 10% of matters go through to decision, and we write a final decision, which is not the ideal solution for anyone. But there are some disputes that are intractable and they need to go to decision, and it can be because consumers are being unreasonable. It can be just that they're complex. There's all sorts of. It can be just that the relationship is broken down. So a general approach to complaints, we must do what is fair in all the circumstances, having regard to legal principles, applicable industry codes or guidance, good industry practice and previous relevant determinations of AFCA or predecessor schemes. Now, being fair in all the circumstances doesn't mean we can override the law. That's not what that means. What that means is that we need to essentially follow legal principles, but there are rare circumstances where that might lead to an unfair result. And in those situations, we can have regard to all those other matters to determine what's fair in all the circumstances. Principles underpinning the process. I've talked about fairness. Natural justice is an important one. Whilst we're not a court, we don't follow the formal procedures of a court for various reasons, primarily around timeliness and cost. Natural justice is important, and essentially that means two things. One is you know what the case is in front of AFCA, and the second is we approach it without bias, with an open mind to either result going through. And there was some comments around that in the independent review, and no instances of bias were found against AFCA, and I'll talk about that in a minute. Accessibility, we deal with a whole range of the population, so we need to be accessible to everyone. Some people are financially literate, some aren't, and you have a broad range in between. We try to engender trust with both parties. We try to be simple, consistency with flexibility, timeliness, efficiency, transparent, and with effective engagement. One comment I would make here is, I know people do get lawyers to represent them, and then they tell me about how much it costs to defend a claim at AFCA. You're not required to be legally represented. Lawyers don't always help, with all due respect, in terms of getting these disputes resolved in an efficient manner. So it's something to always bear in mind. But having said that, you're obviously entitled to legal representation, and that's an option that is available to you. Now, I'm going to talk about one of the substantive matters on our plate at the moment, which is the response to the independent review. Firstly, it was released on 25 November 2021. It was designed to be done 3 years after commencement. We commenced in 2018. The overall finding of the review was that AFCA was performing well in a difficult operating environment and a changing regulatory landscape. We successfully brought together the 3 predecessor schemes to produce an effective dispute resolution service for consumers and small business. Whilst it's an endorsement, AFCA will need to continue to develop and improve its processes as it consolidates its place in the financial system. Second comment, so we had 20 disputes and determinations reviewed. As part of that, the government commissioned a former federal court judge, Julie Dodd-Streeton, QC, to review those decisions. And these were decisions people complained to and said AFCA hasn't satisfied its mandate. What she said was, we were overall favourably impressed by the apparently orderly process, the consistent concern to provide procedural fairness, and the respectful communication with all parties, including unsophisticated and demanding participants. We did not find in the 20 cases we examined a single instance of apparent bias or lack of independence. We considered that the written preliminary assessments and determinations were of a consistently high quality, clearly written and logically reasoned. So we were extremely pleased with that. We've done a lot of work in trying to make our decisions readable, logical, and plain English. So it was a good report card, essentially. However, there were things that we need to improve, and we all know some of the things that are going on out there. We know about DH Flinders. We know there are criticisms around our advocating for complainants. We know that there's an issue around wholesale. So this sets out our program of review. And I noticed there are questions coming in, but I think we're leaving those to the end. Is that right? Yeah. So recommendation 1, AFCA should provide, so I'm saying I'm not ignoring you, we would love to get to those, but we'll get through this first. So recommendation 1, AFCA should provide clearer guidance on the circumstances under which a further issue identified during the complaint process would revert to firms for consideration through IDR. So, this is that one where the complainant complains about something. Through the course of the complaint, they either raise other issues, and it's sometimes because they're not successful on the issues they originally raised, or it can include our inquisitorial function where we bring issues in. And this is all about sending them back for IDR. And I sort of see the merit in that. I mean, the system is designed that you are allowed to resolve the complaint internally first before it goes to us. Recommendation 2 is we should consider what's fair in the circumstances, having primary regard to the 4 factors identified in the rules. So legal principles, industry codes, good industry practice, and previous decisions. And what that's saying is a fairness jurisdiction needs to be anchored in those 4 things to provide predictability, to provide clarity around how we're going things. And that if you come to AFCA, it's not going to be a, which way the wind is blowing on a decision. You should have a good idea of which way we're going to go. Recommendation 3, we should not advocate for nor act in a manner that otherwise advantages one party such that the impartiality of the complaints process is compromised. Really important one, and obviously D.H. Flinders was the catalyst for that. We should continue to publish data on timeliness and start publishing data on the full range of complaints it resolves, including those that extend beyond 12 months. Better manage expectations around timeframes, focus on improving timeliness that remain unresolved beyond 12 months. So, I think I talk about this all the time when I come and talk to you. It's a key part of our system is we do things quickly. That's what differentiates us from the courts, or one big differentiator. And ideally, we want to get through things in 3 months. We know that's not the case. And in fact, we have 4% of disputes over 12 months old. And some I know they're, they've been lodged just after AFCA started, to be honest. And we're trying to work those through. There are various reasons they end up like that. Sometimes it's inability to obtain information. Sometimes very, very difficult issues. Sometimes it's about case managers being confident in the approach. So we're working on those things. So, it's a fair call. We should exclude complaints from sophisticated or professional investors unless there is evidence they have been incorrectly or inappropriately classified. It's fair enough. The system is here for retail investors. If people sign away those rights to take advantage of other opportunities by being wholesale, they shouldn't get the benefits of an EDR system. That makes a lot of sense to me. Recommendation 7, our funding model should not disincentivise firms from defending complaints they consider do not have merit and should better take into account the circumstances of small financial firms. It's a really pleasing one. I'm going to talk about the funding model. I think it's a great win for this space. I know I've received lots of feedback over the years and from Phil included about the disincentives for going through to final decision. And we think we've come up with some really good ways to address those problems. So I'm really excited about that in this space, because I hear, you hear lots of positives and negatives about the systems. I really think the way we're going with this is going to help a lot. And I think the response from the AFA has been positive so far on it. Recommendation 8, AFCA should improve the transparency of its fees for financial firms and how the fees are being used to support activities. So that's a fair enough point. Our decisions won't be subject to appeal, is this one, but we should enhance the visibility, accessibility and independence of forward-looking review mechanisms. So what that means is if a decision has implications beyond a particular individual situation, we need to have more sort of consultation around those sort of decisions. So the review didn't find that an appeal process was warranted, but we have to be conscious of some of the implications of decisions and have this forward-looking review mechanism. Complaints about the service should remain the responsibility of the independent assessor. So I'm not sure if you're all aware, but we have an independent assessor who is separate to AFCA, who can look at, natural justice, how we've dealt with a particular dispute. We should ensure consultation is undertaken on each approach document. We're going to work on all these things is the short answer, and our chief has indicated that we will do that. We've got a number of projects underway to do that. All right, so we're just going to keep going through. So I'm going to talk briefly about the funding model, because this is a response to, we were aware of this problem. And so it's a response to the independent review, but I think it's a system that makes things fairer for everyone. But I should say we still are in the process of consultation on it. So if you do have feedback on it, please provide it. We're going about the consultation in a slightly different way to some others. We're not asking for formal written submissions. We're going out and talking to various organisations, and I think we've done the AFA one, and we get feedback via those channels. So if you have any feedback about it, please let Phil know or contact us directly, and we're happy to feed it in. But look, a lot of thought has gone into it. We commissioned PwC. Essentially, it'll be a single low registration fee, $375 for most members, and particularly in this space. We're going to have a simplified complaints fee structure. So it's no longer close at reg, CM1, CM2, conciliation, fast track, standard, complex panel with all graduated fees. There will be basically two sets of fees. One if it closes in case management, and one if it closes in decision. Now, the case management fees escape me for the minute, but I think it's around 2.8. But the decision fee will be 7.5, irrespective of panel, standard or complex. Now, compare that with 13 odd for a panel, 10 odd for a complex, and about 8 for a standard, or 5 for a fast track. So it's a lot more streamlined, but the better news is most people will not have to pay any fee at all. So you get 5 free complaints. So that means you don't have to pay dispute fees on those 5 complaints. So a lot of members in this cohort will be in that category. That means you don't have to pay the 7.5, you don't have to pay the 3, doesn't matter. It goes through to decision, you pay your $375 registration fee. If you tip over the 5 and into the 6+, then there's a user charge, which will be calculated for the next year. So you can see by this, the funding essentially is moving more from a closures to an upfront fee. And obviously that's, as all organisations know, it's better to be have the money that you're using for the year up front rather than be worried about closures. But also it will lie more heavily with the heavier users of the system, which are the banks, which are the insurers. So some of their fees will go up, but most in this group will go significantly down. And we're really hoping that this just disincentivises the settlement of a matter that has little merit in your view, just because of the fee. That's one key thing. So we could talk about this for a long time, but I did want to just mention it because I think it's one of the important things on the go. And there's other forums. We did do a webinar on this, which I think is recorded, and you can have a look at that, or reach out to me if you need further information on it. Statistics. So I always like to do this. We're going to go July to the end of Feb of this year. 45,000 complaints received, 2.8% decrease compared to 2021. That's across the board. 2728 COVID-related complaints, so about 5%. 6.6 financial difficulty. We're expecting that may well rise. 27,000, no surprise, banking and finance. A lot of general insurance. Obviously, the tragic sort of floods in New South Wales and Queensland will unfortunately generate more complaints for us. Superannuation 3445 and investments 2315. Of the investments and advice, that's about 5%. And that's received. So complaints closed. We closed 2,000 during that period. So we're slightly behind where we need to be. We want to be closing, obviously, the amount that are coming in. 13.2 in compensation was awarded, and we took 129 days on average to close a dispute. So that's just over 4 months. So that, but I mean, of course, that includes all the disputes that closed in 3 days as well as the longer one. So it's sort of it is an average. And as I mentioned, we've got some work to do in terms of products. CFD 606, so an area this group probably won't be interested in, although it is interesting to be looking at the commentary around cryptos and the role of advisors in that space. Shares 413, self-managed super fund 193, super funds 183, FX 180. So I'd imagine FX and contracts for difference are not something that this group would be involved with, but that is 780, 800 odd, which is what, a third. Is that product. Issues-wise, interpretation of product terms and conditions, 577. So that is often in the CFD space about, they get closed out. There's a contractual term. Are they operating in line with the contract and fairly? Service quality, 341, which does impact this group. Failure to follow instructions or agreement, which also does. And best interest in inappropriate advice account for 400 odd. 8% odd. Closing 628 at registration and 254 at decision. So it's about that 10%. And, the aim is 90 days. You see we've got 40% over 90 days, which is not what we want. In the advice area for 1 July to 28 February, 457 complaints received and 485 closed, which is good. We're tracking ahead of the number coming in the door. That's 1% of complaints and 9.2 million of compensation. 90 go through a decision, so that's a few more than the IA average. It's more like 20%. Interestingly, a lot are resolved in rules review, 116, and we have a pilot which is now rolled out more broadly, where we're trying to work out unmeritorious complaints earlier, and decline to consider them. And really those ones are around where there's no loss or where the claim has so little merit that the prospects of success are very low. So it's very practical, and we are introducing that as well. 208 days average age of closed complaints, so a little bit older than the average, which is not ideal. Just out of interest, also did a little look at life insurance advice complaints. So that I should say that it's not just life insurance, that's TP to E income protection. So 128 for that period, 0.3% of all complaints received. So not a huge number, $1.1 million of compensation. And I'm going to give some examples around what those are. Premium rises is one that's in there. I sort of look at it that you have two categories, if you like, of complaints. One is that people have been paying premiums for a long time and get to the end of it and say, well, I paid too much for the time and I was over insured. Or you get the other one where they make a claim and they say, well, I was underinsured, clearly. So in some ways, advisors are on a hiding to nothing in that regard. But obviously, we will go through and look at the, know your client, look through how you've come up with the insured amounts, how you've balanced premiums against the salary, against the protection. And I think this always comes down to informed consent and advising clients of the trade-offs and the considerations and having those sort of discussions. So rolling right along, we're going to do the case study. So The first one, as I said, they're a life insurance focus, and I think we will go about 45 minutes and then leave sort of 15 for questions, I think. So in the first dispute, and this is available on the website, 721796, the complainant is Miss P, and brought the complaint as the administrator of the estate of the late Mr. P. Miss P was the late Mr. P's ex-wife and mother to his children. So Mr. P was a client of the financial firm's advisor, and in June 18, the advisor recommended Mr. P roll over his existing super and replace the existing life and TPD cover for $500,000 within a new super fund. The insurer declined the new insurance application due to Mr. P's existing medical conditions, and tragically, he died in an accident on 29 April 2019 without insurance. So it's sort of like that 1 in 1,000 chance that happens, where you've been declined, you don't have new insurance, and the person tragically dies, right? Something which a lot of the advisors are very conscious of, and the ones that I've spoken to, in terms of ensuring that continuity of coverage. And I know I've had discussions around how tricky it can be sometimes to keep the old insurance when, no supers going in there, no premiums, all that sort of thing. Anyway, the estate claimed the advisor should have advised Mr. P to retain the policies, and the estate seeks the benefit of the cover as if it had remained in force. The financial firm says Mr. P was aware that the insurer declined his new insurance application and decided to proceed with the rollover, knowing his existing insurances would be cancelled. So the issue was, did the financial firm provide advice in Mr. P's best interest? Now, interestingly, I have heard the view that we'll always, find a switch or a rollover is not in someone's best interest. Of course, it can be, and it's one of the tips below. And in this particular matter, they found that the rollover was in his best interest. There was lower fees, better options. There were a number of reasons why it was a good idea to roll over. But the essence of this dispute was the best interest duty, as you all know, doesn't just apply with the advice and the recommendation. It applies all the way through the implementation process. And the breach was in the implementation process because so the previous insurance was still in place. They sent off the application for insurance, received the response that there were issues with underwriting because of a health condition of Mr. P, and the advisor quite rightly raised that with the complainant. But what the panel found in this matter, which comprised of an experienced financial planning rep, consumer rep, and the Ombudsman, was that whilst he acted like a mere conduit, if you like, sorry for using the legal term, but merely explained that had happened and didn't adequately advise on the risks. And in fact, sort of discouraged the complainant from keeping the previous insurance because they said that, whilst he's declined at the moment, he might be able to get it in 6 months. Now, of course, 6 months never happened, because he passed away, and he never was able to get it. So the panel found that they didn't adequately disclose the risks of losing the other insurance until the other one was underwritten. So I think, hindsight's 20/20. It's always, we always look back and go, well, that's obvious. And most advisors I talk to will say that, but it didn't happen here. And really it was all about advising of the risk. So I think if the advisor had said, look, if you lose that, okay, you'll get the benefit of not paying premiums, but you'll be in this period of sort of unprotected from an insurance perspective until the new one's underwritten, and the person still wanted to go ahead, probably would have been found in favour of the financial firm, but none of that existed. Was the complaint entitled to compensation? So the finding was that Mr. P relied on the advice of the advisor, and when the new information came to light, Mr P specifically asked for the advisor's advice. But for the failure, the panel was satisfied that if the advisor had advised Ms P to retain the cover, or, alternatively advised clearly on the risks of losing it, he would have retained the cover. And he was compensated $436,437, so which was paid into a trust fund for his children, which was part of the decision. So as I said, these are available on the website, and you'll see who the financial firm is. We publish that, and that will be on the website. The next one is 807187. And we will be, I believe, Phil and Kaz will hand these slides around, so you'll be able to, get access to the numbers and things if you're interested. This one, complainant first saw the advisor in 2013. Her main concern was whether she had enough insurance to protect her and her son at the time of dependent. She had an employer-funded income protection policy, 2095 per fortnight, and 176,516 death or TPD, death and TPD cover. The advisor recommended she increase her death TPD to 511 for life and 464 for TPD. He also recommended she take out 268 trauma insurance. So it's interesting with the, the IDII sort of changes and the limits on income protection, whether people are bolstering it with trauma. I'm not sure, but in this case, that was the recommendation. When she agreed to these recommendations and the advisor applied for the insurance was offered with 100% loading. So the premiums went from 6,000 odd to 12,000. So what's the advisor supposed to do then? Well, this was 2013, so obviously the Code of Ethics applies now. So there's various debates you could have about what the advisor should do, whether they should walk away, whether they should, advise the client again, all sorts of things. But in this situation, the advisor did advise the client of the risk of proceeding, which was that she was on a salary of around 60 to 70,000. So 12,000 of premiums was a significant amount. But the complainant wished to proceed. So he provided the advice on a no advice basis and basically execution only for this reason. And there was an ongoing relationship for 6 years too. So, the advisor's put himself in a difficult position here in a way, because he's gone on a no advice basis and then agreed to provide ongoing advice services. But this one went in his favour. So the complainant doesn't contest the original insurance, but says the advisor failed to adequately advise her to reduce her insurance as her circumstances changed, and is seeking compensation for the excess premiums paid and lost earnings, also seeking a refund of the 2,200 ongoing advice fees. The financial firm says the advisor considered changes to the complainant's circumstances and advised her on ways to reduce her premiums. It says as a result of the advice, she did decide to reduce her trauma in 2016 and cancel the agreed value component of the IP. But for various reasons documented by the advisor, she did not wish to reduce the remainder of her insurances. So was the ongoing advice in the complainant's best interest? On this occasion, it was, and this was one of my determinations. I was satisfied that the advisor considered the key changes to the complainant's circumstances and provided advice in her best interest. Ultimately, it was the complainant's decision. So the original advice, we did look at whether or not the original advice was backed in substance, and it was, and that was dealt with in the recommendation. But that wasn't really the issue because it was a no advice scenario. So as soon as it goes into no advice or execution only, then the advisor is not really responsible for those things. All they are responsible for is ensuring the complainant knows that that's the basis on which the advice was provided. And there was an extensive file note in this case where the advisor explained that, and the complainant wanted to go ahead because she was worried because of her health. She might not ever be able to get insurance again. So she wanted it. There were good reasons why she wanted it from her perspective. Now, in terms of her circumstances, she changed employment in 2014. Her son became financially independent in 2017, and her debt was reduced in 18. There was a further change in employment in 19. Now, She went part-time in 2014, and obviously you can see why you might want to be reducing your agreed value insurance at that time. But the evidence was that the advisor put that to her, and she wanted to keep it at that level. Extensive file note documenting that, because she was worried if she dropped it, she may not be able to get it back. She had a BMI issue, but an iron-related deficiency, which made it tricky in terms of getting insurance. Her son became financially independent at 17. Again, that's a reason why you might want to reconsider the circumstances. But the evidence was the advisor, again, the advisor had considered that and had provided that in the original recommendation. But again, it was provided on a no advice basis. So she's ultimately responsible for the levels of cover. Her debt was reduced in 18. And, so all those things, again, are situations where you would normally review the advice, but the advisor had clearly documented why he did what he did and what he did. And to be perfectly frank, he did all the right things, I think. He advised her not to proceed when there was a substantial loading. On all the points in between, when circumstances changed, he had meetings with her. He explained, he looked at ways to reduce it, despite the fact it was provided early on a no advice basis. And the evidence was she wanted it. And it's a sort of a coherent story because of concerns for her health. Of course, she turned around in 19 and said, well, I've spent too much on premiums, and complained about it. But after a fairly extensive investigation into this, it was clear the advisor had not done anything wrong. So how to put AFCA out of business? We've got another sort of 5 or 6 minutes, and I will go through this briefly. They're not top 10 tips. There's only 8. I'm pretty open about the fact we change these as we go and with what we're seeing. So there's only 8 today, so I'll be pretty quick. Number 1, take detailed file notes. I mean, both those disputes I talked about turned ultimately on file notes and the documentation. The second one, there were very extensive file notes about the meetings and the discussions that were had. And they weren't just formulaic file notes. They were, I won't say the name of the person, but Miss A came in and was worried about premiums. I discussed, it made you feel like you understood what was going on in that meeting. In terms of engagement, what does the client want? How much will they pay? Explain what services you are provided. So in that second example, it was execution only, which changes the whole complexion of the matter, provided it is in fact execution only and the complainant knows that. In my second example, the complainant, of course, said she didn't know that, but the documentation she had signed that she knew that, and there was a file note where he'd explained it. So the two together were pretty, comprehensive evidence that it was adequately explained to her. Also, remember, it's 2013, so the standards now are slightly different. The code of ethics would have a bit of impact here, I think. Turn clients away when appropriate. So consideration on that second one about whether he should have turned her away at that point. And, there'd be some schools of thought now under the code of ethics, you might do that. But I always sort of take the view that if you've gone through all the right steps, you don't have to, because what would happen is you just go somewhere else and try and get that insurance, and maybe to a more dubious type of advisor, who knows? If you've got the relationship and you can help the client, I think I would probably say that you probably should, provided you take the steps. But that one's more about expertise and things. And if you feel you don't have the expertise on the particular area, then to turn them away, because that can cause you problems. Clearly find out from the client what they want to achieve and tailor advice to this. So, we have this debate about product and service, and should you just give a product with the best rated product? I don't always think so. I think it really turns on investigating what the client's after, arriving at that balancing act of premiums, and then looking at the available products for that particular person. Find out what they want to retire at 65 on 50 grand, not just they're interested in wealth creation or capital security. And I should say that these are just observations I'm making based on the decisions that I've seen. So that's really what this is about. Consider inconsistencies in the answers, try to reconcile that with discussions. Explain the risks, especially for clients who want to act against your advice. Good instances of that in those examples, where in one instance the risk wasn't explained adequately, in the second it was explained really well, right? And so it's always good to come to you with real life examples around these. Make the SOA understandable. I personally like to see really clear, short, to the point SOAs, and I prefer any form of communication that communicates the message to the particular person. A lot of people will not read a document longer than a page, and in fact, we found that with our decisions. Even most financial firms didn't read the entire document. They read the first page, which is why we've done a format, which essentially has the summary, the key points. And if you need more detail, you go and look into it further. So make it, understand it, tailor it to the particular client. I think the big cookie cutter ones don't really cut it for mine. And I think AFCA's been talking about that for a while. Super switching and SMSFs, you need good reasons. Doesn't mean you can't do it. You need good reasons to recommend it. You need good reasons to recommend an SMSF, especially where the account balance is low. That doesn't mean that you don't recommend SMSFs if the account balance is low. I know the SMSF Association provided us with some research showing that the $500,000 productivity commission number was off, and it's more like 200,000. I think none of those things are law. We will be looking at the individual circumstances. Do they want to take on the trustee responsibilities? Are they interested? I think still being interested in your investments, or do you want someone else to manage them? I mean, you do need a more active interest, I think, when you've got an SMSF. Don't recommend products you or your client don't understand. I think such an important part for an advisor these days, and the elderly man over 80 who is retired and sort of lives in his own world, trying to work out what cryptos are, or trying to work out the myriad of sort of products out there. It's such an important part. So I think it's really about understanding the product. And I remember a predecessor of yours, Phil, actually, Brad Fox, told me that he used to go into, when he first started the advisory world, read the PDS from back to front, read it in a lot of detail to try to understand it. So such an important part of things. So that is the formal part of the presentation. Do we stay where we are? We stay where we are, and Kaz, over to you for any questions for Shail.
Yeah, hi. Thanks for that, Shail. Great presentation. We've had a few questions come through. One of the questions is asking about if you can explain about the 6-year rule and how that works.
Sure. So the 6-year rule is like AFCA's statute of limitations, if you like. If you go to a court or things like that, there's a time limit for various causes of action. And it's 6 years from when in our case, it's 6 years from when the events occurred or when the person became aware of them, unless special circumstances existed. So, for example, today is the 17th of March? 17th of March, 2022. At least I know the year. And if we go back 6 years from that, you're back to 2014. So essentially, we could consider all matters where the cause of action occurred from 17 March 2014 to now. Anything before that is over 6 years. And I don't want to overcomplicate it.
So it's not 14, it'll be 16.
Oh, there you go. Sorry. Phil is correct to me. 16. This has worn me out. So it's 16. It's 16. So, the starting position is anything from 17 March 16, we can look at. Anything before that, we can't. But there are two exceptions. One is if the complainant wasn't reasonably aware of the loss. So that could happen, for example, if they're invested in something inappropriate and the market's going well. And the second is there are special circumstances where we can look at considering things beyond that time. But the idea is 6 years going back and to give certainty around sort of claims management.
So Shail, interestingly in this context, if in the cases we saw earlier on, there was cases about paying more insurance premiums than they could afford or that was appropriate in their circumstances, given that you pay premiums each year, I mean, technically you could look at it each time the insurance premium was paid, was that appropriate for the client? So it wouldn't just be dated on the basis of when the advice was provided, but on each circumstance.
That's 100% accurate. And the way I think of that is you've got to look at what the cause of action is. So in that instance we talk about, there was the original advice, but each year when he provided advice on the premiums, that is a new cause of action. That's 100% right. So, in that sort of situation, we could look to the reviews after 16, but not things before that. Yeah, that's a good clarification.
But even so, if the advice didn't adequately deal with the future consequences, such as a rapidly rising premiums, for example, that the loss still arises at a later point, even though the advice might have been provided before the cut-off date.
Well, it can get tricky because it's really the case of the ongoing. I'll try to simplify it, but let's just take the ongoing advice scenario. That's right. Essentially every year an advisor is reconfirming that advice is suitable for someone. So, if you're saying, well, in that case, are you looking at things beyond 6 years? Well, you sort of are in a way, because the advisor is reconfirming it. If it's a one-off service, then you might not. But in those ones, and if it's a one-off service, then it becomes a question of reasonably aware of the loss, which might bring it beyond 6 years.
Yeah.
Someone has asked about whether AFCA have done any research into the potential reduction in the number of complaints if there was a fee charged to the client who was actually lodging the complaint.
Yeah, thanks for that question too, Kaz. This was an extensive, so I understand we're talking about the fees charged, and if a complainant was charged, whether we've done any research on that. As I understand it, as part of the funding model, we had PwC involved. That was looked at. Our Chief Operating Officer has a much better answer to this than I'm going to give, but I think the answer is around the fact that no ombudsman system in the world operates that way, where a complainant is charged, I think the safest thing might be, I'll come back to you on that one, because that has been asked and we have an answer for that. So I'll provide that on notice. Thanks.
Okay, that's good. Just a couple of people have actually made comments, not so much a question, but it's more around what you said about the legal representation. Where you said, look, you don't really need to have legal representation with AFCA. The points that people are saying is, well, that's all very well, but, licensees are required to have PI representation. And so in most cases, that there is a requirement for the licensee to have that legal representation as part of their PI cover. So that was really just a couple of people had just observed that. So
yeah, Look, I get it. If it's above the excess and your PI is involved, you'll have no control over it because the PI will often have a lawyer. And that does happen where sometimes late in proceedings where the lawyer gets involved. But I suppose the point I was making is that we try to aim for less legal formality. I mean, I understand you might not have a choice, but I'd encourage even those lawyers to not be approaching us as a court, because I think some of them do, and I don't know if that helps. That was just the point I was making, but take the point that you don't always have a choice.
Just another couple of comments have come through just about access to the recording of this webinar for today. And I just wanted to mention that this webinar is recorded and will be available on the AFA website within a couple of days. Someone had asked about second study that you mentioned, Shail. They were asking about what the case number was. I'm just wondering if you don't have access to that, that content will be available on the AFA website shortly.
Yeah, sorry, I don't have the hard copy in front of me, Kay, so I'd have to go back over this, which I'm sure no one wants to see again. But yeah, it'll be on the in the presentation.
Okay, I will go back to her.
Oh yeah, you got. Actually, Phil might have got. Actually, here we go. We do have them. Thank you. 721-796 and 807-187.
Okay, thank you for that. Just with the 6-year rule question that came through before, someone is asking what would constitute a special circumstance?
Yeah, look, the one that always springs to mind to me is it's sort of linked to awareness of loss. But if someone is in a particularly vulnerable position and might not be aware of their rights, right? So that's the one that I think it's designed for. You know, an example might be, you know, funeral insurance sold to a remote Aboriginal community, right, where they don't really know about AFCA, how it works. If that came in 8 years, we might not apply the 6-year rule. It's rare. But it's there because of the accessibility issue.
Okay. Someone's actually asked, does AFCA follow precedents of past AFCA decisions when making determinations?
Yeah, that's another good question. And thank you for it. It's we have to have regard to previous decisions of AFCA and predecessor schemes. We don't follow them in the same way as a court, but we have to have regard to them. I mean, often decisions turn on the facts involved, but I think if there are instances of inconsistency, I'm very pleased to look at those, because I mean, that's part of my role at the moment, to be ensuring our approach is consistent and clear. But often when those matters are drawn to my attention, they're often dependent on the relevant facts, which is why the change. But I'm more than happy to look at anything individually.
So we've got. It's a rather interesting question. It's probably not one that you can answer. It's about I think it relates to what you were talking about with the second case where you found in favour of the advisor, and it was due to the file noting and the documentation. So the question is, in the event that the advice is presented to a client, and if that client wanted to reduce those sums insured because of premium amounts, is it sufficient to amend the authority to proceed and file note the discussion along with the warnings of those underinsurance or overinsurance or higher premiums?
Look, I can only answer it from my perspective. I think it's a really tricky issue if someone wants to act different to what you've recommended for the advisor, and ensuring that that's documented. But I certainly take a pragmatic view to it, of saying that things might change from the advice, but as long as I can see what's changed and why, and the complainant goes in an informed way, I personally think that's what you're looking to. That's what I'd be looking for.
Okay, well, I think we're at time now, so will we hand back to Phil?
Thank you, Kaz. Appreciate you looking after those questions. And I'd really like to thank Shail for the presentation today. I think that the news about the proposed new funding model for AFCA is really positive for advice. This is a proposal and it's due to kick in from the 1st of July this year, assuming that it gets finalised as it's currently positioned. But the reality that you would have 5 free complaints, which means that you don't live in fear that a complaint could end up costing you $11,000 for a fee-related matter, for example, is really positive. So I think we'll be interested to see how that works through. I also really appreciated the opportunity to talk through those case studies, and I think it was great that Shail positioned it. One went in favour of the client, but the other one didn't. But it is useful to look at those case studies to give you a sense of reality of how you can go through a particular scenario but protect yourself. So I'd like to really thank Shail for the presentation today. We look forward to continuing to work with AFCA, and I'm sure we'll ask Shail to present again in the future. So there will be CPD available for today. The webinar will be recorded, and for those people who haven't been able to see it or haven't been able to stay for the whole session, the quiz will be available to be uploaded and reviewed, and for you to do it that way. All registrants will receive an email confirming when available, and there'll be CPD certificates provided afterwards. If you do have any questions with respect to the presentation today, then please contact us at info@afa.asn.au. And to round it out, I'll thank everyone for attending today. We really appreciate your interest in this. I think it's always useful to hear from AFCA. So thank you to everyone, and thank you also to Shail once again. Thank you.